My name is Michelle Beach and I'll be chairing this session of the Licensing and Public Safety Committee. Thank you for your attendance. Before we begin, can I outline some housekeeping rules? There are no fire alarms planned, so if the alarm does sound, please leave via the emergency doors. Toilets are outside to the left, and can you ensure that all phones are either switched off or kept on silent? This meeting hopefully will be live streamed on the Council's YouTube pages. First item of business is the minutes of the meeting held on Wednesday the 31st of January 2014. Are there any issues to raise on accuracy of these minutes? No. Can I have a proposer? No, thank you. Seconder? Thank you, Margaret. The recommendation that these minutes are approved. All those in favour? Thank you, colleagues. Item 2, public questions. Do we have any public questions?
No, we don't, Chair. Thank you.
Thank you. Item 3, declarations of interest. Members are reminded of their responsibility to declare any pecuniary interest in respect of matters contained on this agenda. Does anybody have any interest to declare? Thank you. Moving on. Item 4, redesignation of town centre Hackney carriage stands. Nathan, can you please present this report?
Yes, thank you, Chair, and good evening to members of the committee. The purpose of this report is to bring the current arrangements of town centre Hackney carriage stands to the attention of the committee and to seek approval to consult on the proposals. You'll find the report begins on agenda page 7, and the recommendations are to note the current arrangements of town centre Hackney carriage stands, to authorise officers to commence statutory consultation to revoke all previous stands within the borough and reappoint the new stands, to delegate authority to the Director of Planning and Property to appoint the stands as consulted upon where no representations opposing the stands being appointed are made within the consultation period, or where representations are made which are deemed to be vexatious or frivolous. To delegate authority to the Director of Planning and Property to determine, in consultation with the Chair and Vice Chair of the committee, whether representations are frivolous or vexatious, and to note that where representations are received which oppose the appointment of the stands which are not deemed to be frivolous or vexatious, a report will be brought back to a special meeting of the committee for consideration as soon as possible after that consultation period. The reason these recommendations have been made, the market traders which once occupied High Street on Tuesdays and now occupy Fazakerley Street, and so the justification for restricting the use of that carriage stand no longer exists. There may be stands which are currently appointed which are not in use and which are not known about due to the length of time since their appointment. Revoking all stands and reappointing them in a single order gives clarity to the trade. And finally, the County Council are in the process of amending the traffic regulation order, and these proposals will bring the appointed stands in line with that proposed TRO. Other options considered and rejected, essentially not to make changes to the stands. This option is rejected as it could cause the TROs to specify one requirement and then the stands specified by us to not match. In addition, failing to contain all stands within one order makes communicating their location with the trade burdensome. I'll move to paragraph 12 of the report and just set out some of the legal considerations and clarify some of the language which is used in the report. So a Hackney carriage stand is commonly referred to as a taxi rank. That's what we're talking about during this meeting. It's an offence for a person without reasonable cause to cause or permit any vehicle other than a Hackney carriage licensed in Chorley to wait on an appointed stand. The legislation gives the council the power to appoint stands for Hackney carriages, and when appointing a stand, the power to set the number of Hackney carriages permitted to be on that stand at one time. It further gives the council the power to vary whether the time or day during which it is operational, or the number of Hackney carriages permitted to be at it, or to revoke the stand. Before appointing, varying or revoking a stand, council must consult the Chief Officer of Police by giving them notice, and also consult publicly by publishing a notice in a local newspaper, and must take account of any objection or representations made in writing within 28 days of giving such notice. Where the council proposes to appoint a stand on a highway, i.e. a highway which is maintainable at public expense, it can only do so without consent of the highway authority. Separately to the appointment of the stands under the LGMPA, under the process that we're going through today, it's possible for parking and waiting on the highway to be controlled by means of a traffic regulation order. The making of these orders is the responsibility of the highway authority, so it's a county function. Those orders can be used to prohibit vehicles other than Hackney carriages from parking or waiting on Hackney carriage stands, and a failure to comply with that prohibition is an offence, and the person may be issued with a fixed penalty notice by Lancashire County Council officers. Moving then to the detail of the report, High Street, Chorley, has long been the principal location for the hire of Hackney carriages in Chorley. In around about 2006, and then since then, the council has appointed both sections east and west of Cleveland Street as a 24-hour, 7 days a week Hackney carriage stand. Following that then, in 2017, a report was brought to committee which set out recommendations to move a number of traders from Chorley Market on Tuesday to occupy that bottom section of High Street, which is east of Cleveland Street. The report stated that this was a temporary measure, and that was to allow a more permanent home within the town centre to be found for those market traders. That recommendation was approved, and since then the stand on that bottom section of High Street hasn't been in operation on Tuesdays between 9:30 and 4:30. So as it currently stands at 22, the authority is aware of the Hackney carriage stands currently. I won't go through those, but at Appendix 1 there is a site plan which will probably make a bit more sense in terms of that, and you'll see on the left hand side of the table at 22 it deals with those the sort of colour coding of what those stands relate to, and should help members to visualise the current arrangements as they are. So that data in paragraph 22 is essentially generated from the traffic regulation orders which apply in the area. We've been unable to verify whether the stands have been appointed under the Local Miscellaneous Provisions Act, and that's due to the passage of time. It's unclear whether there are other stands in the borough which have fallen out of common usage, and so we're not therefore aware of them. Following the resumption of the licensing liaison panels meetings in 2024, trade representatives requested that alternatives to the Tuesday arrangements were considered. Following that initial meeting, discussions were held with the markets team to identify a new location for those traders, which occupied High Street. Taking into account other moves to the traders, namely occupying Market Street, Sackley Street was identified as a suitable location, and the traders were moved from High Street, providing a link between those stalls in the town centre and those occupying Market Street. That therefore means that the High Street section is unoccupied on Tuesdays. So there are essentially those two concerns, whether or not there are stands which are currently appointed which we're not aware of, and also the bottom section of High Street could be available but isn't because of the arrangements currently. So in order to address those various concerns, it's proposed to revoke all of the existing Hackney carriage stands within the borough, and then following that revocation immediately appoint the stands which are outlined in paragraph 28. Essentially redesignating all of those stands correctly and designating the High Street rank, the bottom section, as a 24-hour rank rather than missing out that Tuesday arrangement. The proposals in relation to the High Street stand will bring it in line with the traffic regulation order, which is in the process of being made by the County Council. The TRO will also include provision that at any time the market is located on High Street, parking and waiting will be restricted. And there's no similar provision within the legislation to make that restriction from our point of view, but in any case it would be physically prohibited by barriers in any time that TRO was to come into operation. And then at Appendix 2 there's a draft notice which sets out the position that we're looking at today. Paragraph 31, 32, 33 and 34 deals with climate change, equality and diversity and risk, and then the end of the report deals with the comments from the statutory officers, finance officer and monitoring officer. That's the report then, Chair. I'm happy to field any questions.
Thank you, Nathan. Comprehensive report as always. Over to you, members. Any questions or comments? Margaret.
Can I ask whether this is going to have an impact on disabled people being able to park their vehicles? Because you've said very clearly that with this is designated as a Hackney carriage stand, that no other vehicle will be able to be parked in it. Are there sufficient spaces around to accommodate disabled drivers? Thanks.
Yeah, so essentially what the report is asking permission to do is to consult on those proposals, and if there were felt, that they were insufficient, that could come out through the consultation. The only real change in terms of what's being proposed is the bottom section in High Street on the Tuesday will be designated 24 hours compared to missing out that Tuesday section. And so that won't actually, there's no missing out. That was occupied by market traders at that time. Now it will be occupied by taxis. Actually, it will probably increase the provision of access in that bottom section, because on the opposite side of the road there is, I believe that's a disabled bays, or at least parking bays on the opposite side of the road, which will then become available as the market no longer occupies that section.
Any other questions or comments for Nathan? Roy?
Yeah, thank you, Chair. Regarding the east side, item 29, paragraph 29, really relates that if there are vehicles from the market using the high street, then we're back to the original scheme. Is that right? 9:30 till 4:30, not to be used by taxis.
So the proposal is that the whole of High Street will become a 24-hour, 7 days a week stand, because the market traders no longer use the bottom section, the section closest to Henry Tate's any longer. They've been moved onto Zackley Street.
Yeah, paragraph 29 states that if the market are using the top end, there's going to be barriers put up and it won't be used. So.
So that essentially that's just to allow flexibility. That's the traffic regulation order from county. They're just leaving the potential for if the market were to increase in size, for example, that would allow the market to be used without the need for additional orders. That is, although it complements what our purpose is in appointing the stands, it is a separate issue in terms of the enforcement of that.
Right, okay, thank you.
Aaron?
Thank you, Chair. Those parking spaces you mentioned on the other side are for loading only, but the thing is, disabled people weren't allowed to park there before. They're not allowed to park there now. There's spaces all the way around town, and I'll use the word, they can park illegally on yellow lines unless the sign says different all around town. So unless I'm jumping the gun, I'd like to propose the recommendations of the officers.
Nathan?
Just one further point on that. Of course, when the stands were originally designed, the site, which is now the car park, which used to be the old Buzz Bingo site, was the Buzz Bingo, and so there's a huge amount of parking provision there now. In addition.
Any other questions or comments for Nathan? On that case, then, can I have a proposal for the?
I mean, in the report it says Appendix 2. I couldn't find an Appendix 2 on the sheet.
Scroll across your screen, it should be at the end.
No, nothing on there.
It's just not headed.
Nothing on there, is there?
That one, right?
Oh, right, sorry. Yeah, sorry, I do beg your pardon.
Any other questions or comments for Nathan? In that case, then, can I have a proposal for the recommendations? Aaron, thank you. Seconder? Deidre, thank you. All those in favour? Thank you, colleagues. Moving on to agenda item 5, consideration of revision to the statement of licensing policy for pavement licences under the Business and Planning Act of 2020. Nathan, can you please present this report?
Yes, thank you, Chair. And just to point out for members following along, this is in the agenda supplement, just to make sure that everyone has access to the papers. I'll apologise in advance for this item. The papers were circulated at a late time. It's due to, considerations in internal going on internally until late. So my apologies that they were published at this late stage. So the purpose of this report is to seek approval to consult on a proposed revision to the payment licence statement of policy and to set a licence fee associated with that regime. The recommendations will sound fairly similar to the ones on the previous report. As to note, the amendments to the Business and Planning Act proposed in the Levelling Up and Regeneration Act have been brought into force. To approve the approach to consultation as set out in the report, to authorise officers to finalise the consultation period and then commence consultation on the revised statement of policy. Where no representations are made during the consultation period, or where representations are made which are deemed to be vexatious or frivolous, to recommend the adoption of the revised policy and fee structure to Council. To delegate authority to the Director to determine in consultation with the Chair and Vice Chair of the Committee whether representations are frivolous or vexatious. To delegate authority again to the Director in consultation with the Chair and Vice Chair to make minor amendments to the draft policy following consultation responses, and to note that where responses are received which oppose the policy revision and or the fee structure and which are not deemed to be frivolous or vexatious, a report will be brought back to a special meeting of the Licensing and Public Safety Committee for the committee to consider those representations. The reasons those recommendations have been made, the amendments to the Act have made the pavement licence regime permanent, and the policy revision is necessary to update and bring the policy in line with the amendments to the Act. As it currently stands, there's no fee associated with an application for a payment licence. This was a decision taken by the Council to support hospitality in the wake of the pandemic. This arrangement isn't sustainable, as the regime has now been made permanent, and it's also inappropriate and contrary to the provision of services regulations for other licence fees and or taxpayers to subsidise the cost of administering the scheme. That fee has been set at a cost recovery level. Other options that have been considered and rejected: not revise the policy. It's rejected as the Act has been amended and so the revision is necessary, or not set an application fee. And again, that's been rejected for the reasons set out in paragraph 8 and 9. I'll deal with the background then, and we're on agenda page 20. Prior to the Act coming into force, permission to place furniture on the highway was granted under the Highways Act 1980. That regime required a 28-day consultation period and the fee was uncapped. Through the pandemic and in order to support that business recovery, a new regime under this Act was enacted. The aim was to reduce the burden on business, and the new regime gave a 7-day consultation period followed by a 7-day determination period. It also capped the application fee to £100. The regime could only authorise furniture being placed on the highway where it was for a relevant use, and those relevant uses were where the premises was being used as a public house, a wine bar, or other associated drinking establishment, or some other use associated with the sale of food or drink for consumption, either on or off the premises. So some sort of food or drink use. A licence is permission to put removable furniture on the highway for one or both of the following purposes, and essentially to supply food and drink from or to consume food or drink on them which have been purchased in the premises. The Council adopted a policy in June 2020 which set out how the Council would administer the scheme. When the Levelling Up and Regeneration Act was enacted, there were a number of amendments made to the Act. Some of the significant amendments are summarised at paragraph 19. That was an increase in the fee cap that went from £100 to £500 for a new application, and then introduced a renewal fee of £350, a cap for a renewal fee at £350. It's to increase the consultation and determination period from that 7 days to 14 days, and that was each for the consultation and determination period. Increase the maximum period a licence may be issued from 1 year to 2 years. It removed the ability, what used to happen is it was up to the applicant to decide whether they wanted to apply under the Highways Act or the Business and Planning Act. When the amendments were made, it essentially meant that where it was possible for a licence to be granted under the Business and Planning Act, that was the only option. And then it provided new enforcement powers to take action against unlicensed or furniture which was placed on the highway which didn't benefit from a licence. There's therefore a revised draft policy at Appendix 1, and the changes have been summarised in the table at Appendix 2. At Appendix 3 then there is the fee justification. That process is essentially maps the average time various officers spend in relation to an application. That forms the basis of a matrix when compared to the cost of the council of that person or that officer per hour. Fees have then been rounded to the nearest £10, and the fees recommended for a 2-year licence are therefore set at, for a new application, £350, and for a renewal application, £100. The difference in the fee is twofold. One is around the cost of administering the revision to the policy, which would be applicable on a new application but probably not on the renewal, and then the conduct of an inspection, which would be carried out on a new application but not on renewal, provided all of the information was the same. We estimate that the 20 businesses will make use of a pavement licence, and therefore it's anticipated the fee generating in the region of £7,000 over the initial 2-year period, and then £2,000 for each 2-year period thereafter. That fee will be kept under review based on the number of licences which are issued and may be revised from time to time to ensure it remains set at a cost recovery level. It's proposed to consult on the revised policy and fee justification over a period between July and September 2024, and in order to ensure relevant stakeholders are included within this consultation, it's proposed that the following businesses and or bodies are consulted, and that's all licensed premises, all food businesses, and their appropriate disability or additional needs support or advocacy groups. Again, at paragraph 25, 26, 27 are the sections on climate change, equality and diversity and risk, and then the report closes with the comments from the statutory officers. Again, Chair, that's the report. Happy to take any questions.
Thank you, Nathan. Over to you, colleagues. Any questions or comments for Nathan? Roy.
Thank you, Chair. I presume this applies to all the rural districts as well, does it? Croston, Coppell, everywhere? Yeah.
Yeah, it'll apply equally across the borough.
Secondly, if say a food place has got a licence to sell food, but not alcohol, and they have a stall outside, and somebody comes in drinking alcohol in there, how does that work?
This policy is just to deal with the placement of tables and chairs on the highway. So the
yeah, but if the person who's got a food has a license to sell food, not a license to consume alcohol on the street, have they?
Yes. So the consumption of alcohol is not a licensable activity. So it doesn't to consume alcohol anywhere. You don't require a license for that. In some parts of the borough, there is a public space protection order which prohibits on-street drinking, mostly around the town centre. In any place that benefits from a pavement licence, those provisions don't apply. So it's permitted for people who are drinking alcohol within a licensed pavement licence area. They are permitted to drink that, regardless of whether or not there's a public space protection order.
But what I'm referring to is the gazebo outside Charlie's Chippies at the side of the market.
Okay.
Now, I presume that's Charlie's Chippy who are providing the things for that, but yet people are buying alcohol at Bob Inn and drinking it within that seating area. So how do they get over that?
Perhaps we deal with the general principle of the idea, and then I can discuss the specifics of that case with you, perhaps outside of this meeting.
Because the item refers to the premises can put seating on for consumption of alcohol which they provide. regarding that particular gazebo, Bobbin are providing the alcohol for somebody who hasn't got a licence to serve alcohol.
Yeah. The permission that is dealt with in this agenda item is just permission to put tables and chairs on the street. So it's completely separate from any alcohol permission or any sort of food permission. And so I think it's.
What you're
sort of
saying
going
is they
across.
wouldn't be able to drink within that gazebo. They shouldn't be
I
able to
think,
drink.
Roy, this is a discussion that you need to have with Nathan outside of this forum.
Okay, thank you.
Christine?
Thank you, Chair. Is there any leeway in these, like the rules around when you put the furniture outside and you're given a time of when you're allowed to sit outside and use that furniture, and then once that time's up, you've then got to pack that furniture up and store it. What if the business works till after that time and they haven't room to store it until they've emptied it completely? Are you going to give any leeway or anything to those premises?
Yes. So any council policy is always the sort of guidelines of principles what is expected. The council can always depart from policy with good reason. Some other types of businesses which may want to leave their furniture out, all the time, they are still able to apply for permission under the Highways Act, and that permission is, can allow them or give them the permission to leave their furniture out, 24/7. So it would just depend, in a case of what the arrangements were and how it fit in that particular part of the
That could
street.
actually lead to antisocial behaviour if there's furniture hanging about, isn't there? That's great.
Yeah, and within the scheme of delegation, it's a straightforward matter within the arrangements. If it does contribute towards antisocial behaviour, there's the power to revoke a licence, or also a power to issue improvement notices. And one of the key things in this within the revisions, within the new powers that were brought in, the power to deal with unlicensed premises, unlicensed pavement areas. Before these new revisions were brought in, essentially any obstruction on the highway had to be dealt with by the highway authority, and so the district council didn't have any power to deal with the unlicensed ones. So it's a beefed up regime essentially.
I'm sure I read somewhere in the report, and I can't find it now, that you've got to have smoking and a no smoking area even outside, and there's got to be a space between the two. Is that correct?
So that was what they were the national conditions that were proposed under the initial act. Those national conditions haven't been brought forward in this revision, and so they've been removed from the requirements. We would always give that advice, and generally businesses are pretty good at recognising the needs of smoking customers and non-smoking customers, and we'll generally make provision for that in any case.
And also, can I just ask, I understand that when a premises is licensed, it draws a red line around where that licence extends to, does it? So if they're granted this easement, does that licence area become definitive, or does it remain as it is but with this additional permission?
Yeah, when we're talking red lines, are we talking alcohol licence in there? Right, okay. Most venues which make use of pavement licences will be making off sales, so they'll be supplying alcohol for consumption off the premises, and so any conditions which relate to those off sales will apply to the drinking within those pavement licences. The government is consulting currently on, the previous government was consulting on whether to automatically extend that into pavement licence areas. So that may come out, in due course, that it's sort of automatically added into that area. Obviously, I can't talk to it until that consultation is carried out and whether it changes with the change in government.
Okay, thank you.
Thank you, Christine. Mark?
Thank you, Chair. I can see on paragraph 26 that it does reference there are minimum recommended distances to allow visually impaired persons and wheelchair users to be able to navigate safely around pavement licensed areas, because I have been contacted previously about this and worries, so it is good that that is in there. And in terms of obviously the charging element, looking at how much it does cost to actually bring these in, obviously the council, as was mentioned before by Nathan, that you can't be subsidising really these sites, so it's high time this comes in. And also if you were to purchase the square footage of these and pay business rates in, these actual charges are a bargain in my opinion. So I'd like to recommend we go ahead with the recommendations on this.
Thank you, Mark. Does anybody else have any comments or questions for Nathan? Yeah, of course you can.
Yeah, and I think that's one of the key things about this, the way this policy operates in terms of the minimum distances. And one of the, I know there have been concerns raised in the past about businesses which don't permit that minimum distance. Generally speaking, that would have been because the business wasn't licensed, and the struggles that, you know, because we didn't have the enforcement powers, we weren't able to deal with that. With this, with the amendments, then we will be able to deal with those issues.
Thank you. I have no more questions or comments from colleagues, so we'll move to the vote. Can I have a proposer for the report? Mark, thank you. Seconder? Aaron, thank you. All those in favour? Thank you, colleagues, and thank you, Nathan. Moving on to agenda item 6, minutes of the General Licensing Subcommittee that was held, hasn't been once since the previous meeting on the 31st of January, folks. Can I have a proposer and a seconder for those? We're just noting, all right, so they're just for noting, colleagues. Item 7 again is just for noting the minutes of the Licensing Act 2003 Subcommittee from the 31st of January this year, there for noting. I have not been notified of any other urgent business, colleagues, so with that, thank you very much for attending. Don't all disappear though, because I've got something to ask on behalf of the chair, as it's